Good morning, Dan. Thank you very much. And it's a pleasure to be here with you all this morning. Just before I even get started on my prepared remarks, I wanted to try to catch the ball that Paul had passed to me in regards to the question. So as an attorney, I can, very much enthusiastically support Paul's decision to avoid depositions because as a litigator, I know how much effort, cost, and pain those can inflict, and as we've sort of been in the throes of that even these days. But I very much enjoy what I do, and I just wanted to explain sort of, at least from the U.S. perspective, the question raised the distinction between commercial or small business lending and privacy protections versus consumer lending. It's a great question, and I can talk a little bit about the laws. The first point I just wanted to share with everybody is that, in the United States, there's both the federal laws and statutes and regs, as well as each of the 50 states and DC have their own codes as far as regulation of commercial lending versus consumer lending. In the federal system, what I think is very poignant about the question that was raised is that it's spot on. There's definitely, even in the legal definitions, a hard distinction between consumer protections for consumer lending versus commercial. And I'm going to get into this later on in the presentation, but we're in a very meaningful point in time in federal consumer financial protection history because the CFPB is poised right now to delve into the waters for the first time of regulating small business lending, but it comes up in the context of anti-discrimination, the 1071 small business data collection rules. So I'm very ecstatic about the question because it really highlights the sort of the old world versus the new world. The old world being that, complete distinct silos between consumer and small business. New world is we're slowly seeing that line, bleed, consumer protection like concerns bleed over into small business lending as well. And I think that is happening, my personal view, because the law is evolving to keep up with the pace of innovation and what's going on in the markets. So going back to my agenda, as many of you know, the CFPB is the regulator in DC charged of consumer financial protection. And I very much appreciated Dan's opening remarks this morning regarding the cultural moment that we are in. And so I can fairly say that our agenda for this session is to discuss the CFPB's role as a regulator in the context of that cultural moment. From reading the news headlines, you've all seen that the CFPB has been very active throughout the last 10 months, but especially only 5 days ago, the Senate has confirmed Rohit Chopra as the new director of the CFPB. And given that breaking development, we will also later on in this session talk a little bit about the significance of Chopra's leadership as well. Just to start out, I wanted to focus on a couple of the key rules as they relate to data access and fair lending, and also touch upon CFPB enforcement, which is very crucial given the nature of the agency. And if any of you have any questions for me about the CFPB or our practice, I'd be delighted to answer those as well at the end. So the next slide. I wanted to first discuss the Section 1033 of the Dodd-Frank Act. It's essentially a provision governing privacy and data access. And many of us are all too familiar with rules in other jurisdictions, whether it be the GDPR or the California CCPA and the amendments there too, or even some of the new privacy legislations that have been passed more recently in other states. But what people may not be as familiar with is the new CFPB rule being proposed on Section 1033. Section 1033 is a provision that authorizes a federal agency for the first time ever to essentially protect the consumer's right to access their data. And it states that, as usual in a lot of agency rulemaking, the statute sets forth the substantive goal, if you will, and then kicks it down to the agency to write regulations to flesh out the precise requirements of that law. And on this slide here, we have just set forth a brief timeline to provide you with context on how far back these efforts go. So even in February of 2020, the Bureau had held a symposium on the, I might have a guest here coming in to join us briefly, but sort of the realities of our times in this period of COVID. But so going back to the slide, essentially the Bureau or the CFPB had in February of 2020 held their symposium. Even under the Trump administration, they had already gotten started on making good progress on this rule. Next slide. Who should care about the Section 1033 ANPR, Advance Notice of Proposed Rulemaking? So it would be any covered person, and that's a defined term in the statute, or anybody who partners with a covered person who deals with consumers' data in connection with consumer financial products or services. So in our view, this would cover a large watershed. It would be financial institutions, non-bank financial services providers, payments, lead generators, peer-to-peer lending, credit score improvement companies, financial management apps, and any other type of business that engages in transfers of financial records. Could it be the CCP on steroids? Could be, because it is a federal rule, and we're in the very early stages and kind of poised to see which direction that the agency will go. And we've included a resource here for you, an article that we prepared that describes one type of API scenario and how that would apply in relation to 1033. You can feel free to look that up at your leisure. In the next slide. So here I've just verbatim quoted the language of the statute. Essentially, it's subject to the rules that the Bureau will later issue and prescribe. A covered person shall make available to a consumer upon request information in the control or possession of the company concerning the consumer financial product or service. So it's a very sparse bit of language, hence the need for rulemaking to further flesh out the specifics. Next slide. So what we've done here is we have distilled the very large ANPR document that the CFPB issued into 8 key concerns that we feel are most pressing from the viewpoint of the CFPB. And I'm not going to read all of them, but I just did want to highlight a few. So, number one, the CFPB is seeking the public comment on the harms and benefits that may arise out of consumer permission data access by third parties. I think they're really getting at issues of, transactions involving APIs, financial institutions, and third-party service providers. Wanted to also highlight number 7. So what's very interesting about number 7 is that here the Bureau is getting at potentially their foray into writing substantive standards for data security. In the old world, we certainly had the Gramm-Leach, and we still have the Gramm-Leach-Bliley Act, the data security standards, the safeguards rule there. In the Fair Credit Reporting Act, we have some rules in relation to how consumer report information should be handled to be safe. But this is a pretty big deal because this is the Bureau potentially writing rules, including possibly technical standards in how data security should be done in the context of these consumer data access rights issues. And essentially, in my view, I just think that this is a culmination of a multi-year long effort, probably dating back to 2018, 2017 even. There had been, I think, industry initiatives between different subsets of the financial services market. So fintechs and institutions negotiating bilateral agreements to talk about, when we're going to be making transfers of consumer data, what will be the rights and liabilities between the parties, error resolution obligations, breach liability, and that sort of thing. And there had been just zero regulatory rules. The Bureau had issued a principles document, principles at a very high level that generically stated what the Bureau expects from a consumer protection standpoint, but no actual rules of the road, if you will. And so, I think for many years, as we saw proliferation of new fintech services that rely upon APIs, and financial institutions also rely more upon digital banking and different offerings that rely on APIs. I think the industry had previously relied upon self-regulation, if you will, and these agreements. But now here we have the 1033 ANPR, which may potentially provide more direct restrictions to the industry in relation to all these subsets of market actors. So I guess I want to also just briefly add one final point about 1033 before I get into the next rule, given the comments I had heard this morning. So my personal observation, too, is that this 1033 rule has the potential to solve a lot of problems. We're talking earlier in the prior session about consumers' expectations. And, we think a lot in our practice as we're guiding our clients about our clients' goals to eliminate, as they're innovating new products, FUD, consumers' fear, uncertainty, and doubt. And just the sort of the chief goal of eliminating the friction that's presented to consumers when they seek to transmit their data or give consent for their data to be used by other apps. And, those other apps may be retail outlets, online, or lending services and products, financial management apps, or other types of purposes in these apps. And the 1033 rule, I think, is the kind of manifestation of the federal government in trying to step into the field and essentially implement restrictions, potentially impose liability standards, essentially write this brand new rule that had never before existed that could fundamentally alter the way that companies do business in this space. I think the consumer advocate concern that we sort of see as a public policy matter is that, yes, it's great when consumers are given ultimate control over, providing consent to use data or transfer data. But what happens if there's a lack of transparency in how the data is used so that this consent is not knowing consent or voluntary consent, or what if there are false expectations in how the data is used? And as we've seen over the last 10 years, which is how long the Bureau has existed, the consumer advocate the consumer advocate viewpoint features prominently in a lot of the Consumer Financial Protection Bureau's policies and objectives. So I think that that's another problem, I suppose. If you agree it's a problem, some people think it is, that the Bureau's 1033 rule could really help market players, advocates, and consumers to solve. I guess the last thing I'll talk about here on my kind of 1033 remark is there's another issue, relating to the expectations of incumbent players, financial institutions, and traditional banks with brick and mortar stores versus fintechs that are offering products that are digital and mobile banking and have no stores. And the old regime, there are and have been for decades old laws that set forth in the banking world risk management, error resolution procedures, protocols for credit card refunds, electronic fund transfer error issues, but in a fintech environment where the regulators are dealing with previously non-existent technologies, how do those old error resolution and other consumer protection rules apply to new technologies? And I think that this 1033 initiative has the potential to nail down the solutions to many of these issues. Or if, depending on how the CFPB does, it may utterly fail. But what's exciting about this moment is that we're all sort of watching and seeing how the agency will go. And also the agency has been soliciting comments from the public, industry actors, consumer advocates for their input on how all of this should go. And the next rule I wanted to briefly touch upon is, as I mentioned earlier, it's the small business lending data collection rulemaking. The next slide, please. So this is the section 1071 of Dodd-Frank. And I just wanted to talk a little bit more about the overall context of what this is. What did we have before 1071? Well, so we had the Fair Housing Act, which the DOJ enforces, and we had the Equal Credit Opportunity Act that the CFPB enforces. And in those laws, there are, theories of disparate impact liability. So essentially, at a super high level, it's the idea that a company may still be liable for discrimination, even if there's not evidence of intentional discrimination, and there's only evidence of a pattern of a disparate impact. And I think just in terms of the concept of the cultural moment and we are in, we're kind of following decades of, I suppose, policy concerns, legacies that some view we have inherited in redlining and home ownership, and a very present day need currently to address issues of systemic bias in different systems in our society. I think that's certainly the view, I believe, of the Biden administration and other leaders in the Bureau. So against that backdrop, enter the CFPB. What the CFPB is poised to do now is to look into data collection to address credit applications from women-owned and minority-owned businesses. And essentially, the Section 1071 was an act of the Congress that had amended ECOA, Equal Credit Opportunity Act, to require the financial institutions to collect and report information concerning credit applications by women-owned or minority-owned small businesses. As I mentioned earlier at the top of the session, this is the first effort of the Bureau in its 10-year history, where it is now embarking on regulating B2B loans instead of staying within its territory to regulate B2C loans. And if the rule is finalized as proposed, it will create the first ever database in the US of small business credit applications that will allow the regulators, as well as the public, as well as consumer class action attorneys, to identify fair lending concerns among small businesses. It would also allow stakeholders who are concerned to better identify their community development needs and opportunities for small businesses. Some are very worried that this new rule will impose an extraordinarily burdensome compliance and collection and reporting regime that's similar to what we already have now under Home Mortgage Disclosure Act, or HMDA. And I know that's a very real concern because the Bureau, as I understood, had used the same blueprint for the HMDA data collection vendor as what they are now setting up internally for potential 1071 data collection. Again, as a litigator, I can also vouch for the concern which arises in the potential risk of increase of frivolous lawsuits, sadly, because the database may allow for data mining that would detect lawsuits based on patterns in the data. When you marry that with the legal principle of disparate impact in fair lending, or I guess anti-discrimination issues, then that may be a perfect storm for an increase in litigation as well. And just for your own information, on slides 7 and 8, which are the next two slides, if you might be able to flip over to those. We've just presented some more background information on the rule and the timeline as well. This provides a little bit more background on how far back the Bureau's efforts go. And true to the Bureau's promise, the agency had issued a proposed rulemaking just a few weeks ago. The next slide. Okay, so that one was the one with all the milestones. And then the next slide. Okay, so finally, a talk about the Bureau would never be complete without a comment on enforcement. And just in terms of contextual placement, what we have seen in enforcement and in the CFPB's growth trajectory in general, starting at its inception in 2010, 2011, is that even during the Trump era, the enforcement group kept itself alive within the Bureau, but there were just different emphases on what kinds of cases to bring, notwithstanding public media reports stating that the Bureau had died in terms of any enforcement activity. Under the Biden administration and the new Congress, where both chambers are controlled by Democrats, we're poised to see a much more active CFPB enforcement regime. There's no doubt about that. It already has started happening from January to October of this year. And then, of course, Director Chopra was confirmed last Thursday in the Senate. There always have been concerns about the CFPB in terms of the authority and the power of the CFPB. Senator Toomey on the Senate floor last Thursday called the Bureau arguably the most unaccountable agency in the history of the federal government. This, of course, echoes the sentiments of then DC Circuit Judge Brett Kavanaugh, who had authored the opinion in this PHH mortgage case, which had talked about the CFPB director as the person who was the second most powerful person in the country next to the president. And, in slide 10 here, what we've done is we've just noted some of the key areas. Oh, we can go to the next slide, I think. Thank you. These are the key areas that the new Chopra-led CFPB and the Biden administration will be focusing on in our view. And the overarching theme here is that there will be a sharper focus on consumer data issues and enforcement. Next slide. This particular discussion is a little bit wonky for lawyers only, perhaps, but one of the major legal issues, in my view, for CFPB jurisprudence and development is who does the CFPB even regulate? You might recall that there was a time when the Bureau was pursuing telecom industry actors, auto dealers, retailers, propounding very new and creative angles to expand the scope of its authority. And a lot of that was done under this definition of a covered person in the Dodd-Frank Act. And what we've already seen is that in the beginning months of the Biden administration, the Bureau is still continuing to march down that path. And in addition, there had been an executive order earlier this summer by President Biden where he had a special shout out to the Bureau, two issues. One is asking the Bureau to please make sure that you guys make good progress on this 1033 rulemaking, the one I spoke about earlier. And then secondly, that the Biden order specifically identified that the CFPB needs to continue enforcement actions to enforce the ban on UDAP, unfair, deceptive, and abusive acts and practices, which often come up in the context of privacy cases and privacy violations. Just a couple of quick comments on Director Chopra. Well, in terms of the long view, kind of dating back to history, I personally think that what we see in the beginnings of Director Chopra's leadership is that we will now be able to marry the existing 9-10-year-long trajectory of the CFPB in its interest in tech issues with an executive leader who personally places fintech issues, artificial intelligence, machine learning front and center in terms of his mindset and vision for how to do consumer protection in the digital economy. And Chopra when he had spent 3 years previously as a commissioner at the Federal Trade Commission, he had written extensively about technology companies, and he has a very deep and sharp interest in the fintech's use of AI and ML. The acting director, Dave Wajo, he'll remain the head of the bureau until Chopra leaves his current post at the FTC, which we expect will occur by late next week. And the bureau has already begun sending civil investigative demands to companies that are using alternative data and artificial intelligence in lending decisions, insofar as questions of do those technologies help accelerate fair lending law violations. And so, I think that the theme of the conference very much dovetails perfectly with the CFPB regulatory update in terms of the idea that there are new restrictions and regulations coming down the pike. But in addition to those potentially imposing obligations, they also present tremendous opportunity for companies and businesses, especially that have a lot of technical expertise in being able to distill lofty policy concerns and directly translate those into technical action items. I think there are a lot of opportunities through the rulemaking efforts of the Bureau and other efforts at the Bureau to utilize this cultural moment and the Bureau's efforts in law enforcement to display a company's competitive advantage in how the company is treating consumers and protecting consumers. So with that, I'll just close my prepared remarks, and I'm happy to take any questions if we have time.
Jenny, that's great. And I'm going to just stick to one for myself. And then I'd love it if we have one or two that come in from the group. But, you mentioned Chopra's experience and interest in fintech. And so I know that you've kind of covered this in a sense, but if you had to just encapsulate, where do you think the CFPB, this calls for speculations, you're going to say it right up front, right? That I'm looking for you to, just give us the short version and maybe just project, but where do you think the CFPB wants to go or might try to go on fintech?
It's a great question. And I think at a high level, and then I'll talk about the bits of how it would manifest in specific issues. I think at a high level, the CFPB is going to confront the problem of fintech and regulation. And I'm not talking about the problem of something being harmful or wrong. I'm talking about the new wine into old wineskins problem, where there is no federal statute that says this is the fintech consumer protection statute. Instead, we have 18 different federal statutes, UDAP and military lending, and it's truly a patchwork quilt. And so the fintech's activity is really what governs which laws get triggered. And this, I think, is almost a logistical nightmare for regulators, because it's not always obvious, especially when the regulator's knowledge of the technology and the facts might be behind the knowledge level of the industry. I think the Bureau might really try to streamline, pick out a concise and consistent approach to which laws they even will use to address the fintech industry. And I know that's pretty abstract, but from a legal perspective, I think it's significant because it's a problem that's been, long in the tooth for many years. And now I think we see the Bureau officials coalescing to impending action. Now, how would that actually manifest? So I think definitely financial data privacy rights, like the 1033 rule, in terms of how fintechs are using the data, but also how they are describing the use of the data. When they advertise or explain in their terms of use or on their websites how the data will be used, how consumers can opt out, or how the data is sold. I think that any of those things, if there's ever an inconsistency between how we describe what we do versus what we do, that will be an area that the CFPB will very much look into. And also then there's multiple issues. I think Fair Credit Reporting Act. So who constitutes a consumer reporting agency? If there's data aggregators that are potentially in a gray area, I think the Bureau may go after those sorts of issues in terms of trying to include more companies to be regulated by FCRA than they previously had before.
Yeah, absolutely. We'll leave it at that, but I got to toss this out there, which is there's so many ways that I think we've taken for granted that information has been used for a long time in some ways to make decisions that we're going to revisit now, right? And I don't know if this particular example comes into it at all, but as I've had before, we got a couple of teen drivers in the house, and so I get this thing from our insurance provider saying, "Hey, send us your kids' high school transcripts if their grades are good, and they get a discount." And of course, the practical aspect of me says, "All right, well, how do we find the transcripts, whatever, because they would get a discount." But the nerd in me says, "Really? This is what we're doing?" You don't have to be an education policy expert to know that there are strong socioeconomic correlations with educational credentials. Like, everyone knows that. So it's that kind of stuff that I think we've done for a long time that it seems to me is kind of an open cultural question. Like, are we doing this? So I think there's a lot of stuff that may be, revisited that we maybe don't even think about. And some of it will be through the CFPB, and maybe some of it's just going to come through, consumer action or whatever. Interesting stuff. Jenny, I'm grateful for your expertise and your time and your thoughts on this. And, we're shifting from your presentation to personalization, but just close out with you by saying thank you so much.
Yeah, thank you. My pleasure.